Welcome to the First Amendment v. Copyright panel discussion embedded in David Herlihy's Copyright in the Creative Industries course and my Introduction to Film Production course. David and I both teach in the College of Arts, Media, and Design at Northeastern University, and we work together to bring you this event. We are pleased you can be with us. I will now introduce each of the panelists, and they will share some opening remarks before we get into the discussion. We're joined by students in our classes who are asking questions in the chat. Our first panelist is David Herlihy. He is a teaching professor and coordinator of the music industry program at Northeastern. Since 1993, David has maintained an intellectual property, new media, entertainment law practice in Newton, Massachusetts. He received a BA in political science from Boston College and a Juris Doctor from Boston College Law School. All right, David, take it away.
Yes, thank you, David, and welcome everybody. This is a topic that's very near and dear to my heart. I am, in addition to being an attorney and a professor, I'm also a musician and a creator. I'm actually working on a bunch of new music right now. So the intersection of law and creativity is very near and dear to me. And so one of the things that we think about is this notion of property and what property is. And there's real property, and there's personal property, intellectual property, and tangible property. And so, property basically allows you, the owner of that property, to exclude other people from using it. And they can decide how they want to use that property. They can sell it or license it or lease it. And so, there's so the idea of intellectual property is actually rooted in the Constitution, and it's Article 1, Clause 8, Section 8, which is called the Progress Clause. And it enables Congress to promote the progress of science and the useful arts. And by science, they meant knowledge and learning. And so the bargain that Congress struck, which they actually borrowed from the Statute of Anne in England, was this idea of a short-term monopoly. They grant quasi-property rights to authors and inventors to their writings and discoveries. So the Progress Clause deals with copyrights and patents. And so copyright is it's an intangible right. It's a bundle of rights. There are 6 exclusive rights that are enumerated in the Copyright Act: the right to reproduce the work, the right to adapt the work, the right to distribute the work, the right to perform the work publicly, the right to display the work publicly. And there's also a right with respect to sound recordings. But basically, the owner of this intangible intellectual property has the right to do any or all of these things and to authorize others to do that. And so the reason we have copyright, which is this monopoly, is because it promotes progress. And it depends, so that there are some competing interests in this balance. On the one hand, you have the public good, which is really the primary purpose of copyright, to enhance knowledge and to enhance learning. And so we grant this time-limited monopoly to authors as a secondary grant so that they may do something which benefits us all. So on the one end of the continuum, you have public good. At the other end of the continuum, you have private gain. So this property right and this quasi-property right that we grant to authors and to owners of copyrights. But a third purpose, aside from the public gain, public good and private gain, is also supporting and promoting innovation. And so you have this balance that Congress is trying to do, and sort of achieving that balance between the public good, private property rights, and supporting innovation. So there's a tension between speech and follow-on creativity and exclusive rights. And so how do you strike that balance between the property owners and the public gain, and say sort of follow-on creators who want to make use of these works for further public edification and public good. So Lawrence Lessig is a professor at Harvard Law School, and he's a very influential thinker in this space. And he coined the term Disney creativity. So Disney creativity is this term, as I say, coined by Lawrence Lessig. It's a form of expression and genius that builds on the culture around us and makes something different out of that. And so Disney in the 1920s, he made a whole bunch of new work from works that had just been in the public domain, Grimm's Brothers fairy tales, but the list of works that Disney created by borrowing creativity around him is astonishing. You have Snow White and Fantasia and Pinocchio, Dumbo, Bambi, Alice in Wonderland, Lady and the Tramp, Sleeping Beauty, Sword and Stone, 101 Dalmatians. Again, all of these things were created by Disney by using something that was around him, and he made something new of it. So in 1928, when Walt Disney was doing that work initially, he was free to draw on relatively fresh culture because the time period then was about 28 years. And so most of the content from the 19th century was free for Disney to use and build upon. And so this idea of sharing and sharing knowledge, Thomas Jefferson talked about knowledge being a candle, a taper. If I light David's candle with my candle, his burns brightly and mine burns brightly as well. So the fact that I share my flame with David doesn't diminish mine. And that's a real difference between physical property, like a car or something that's made of atoms, and intellectual property. The sharing of it does not diminish it. And so it's what economists call non-rivalrous. And it's also non-excludable. Lighthouse light is non-excludable. If you don't pay for the lighthouse light, it still works for you. So there are some differences between intangible property and intellectual property and real property and physical property. But basically, we create these rights to foster further creativity. And so fair use was actually something that was created by judges in the 18th and 19th centuries and 20th century as well. But they would look at a case where somebody had borrowed something from someone else, and they said, well, yeah, it literally is an infringement of copyright, but this is for a productive social purpose. And so we don't want to give the owners of copyright absolute veto power over follow-on Disney creativity. And so judges began to look at cases on a fact-by-fact basis and say, well, this is a violation of copyright, but it serves a public good. And so they developed these fair use factors, one being the purpose and character of the use. What are you doing? What's it for? Is it for profit, not for profit? What kind of work is it that you're borrowing from? Some works are more freely borrowed from than others. For instance, like an autobiography may be more freely borrowed from than, say, a creative work. So the nature of the purpose and character of the use, nature of the work, the amount and substantiality you took compared to the whole. How much did you borrow from the work? The less you take qualitatively and quantitatively, the more likely it is to be fair. And finally, what is the effect of the use upon the market for the work? Are people now no longer going to go to the first work because the second work borrowed so much of it that it hurts the market? So Congress codified that fair use, those fair use factors made by judges, into the Copyright Act of 1976. So Section 107 of the Copyright Act deals with fair use. And as I say, the law is a balance of exceptions to the use and rights. And the exceptions, the biggest exception is, and my favorite, frankly, is fair use. And it's codified in the Copyright Act. And now when there's a fair use challenge or a fair use situation, judges, litigants can go to court, and judges will look at the statute and they'll apply the factors to the fact pattern and decide whether something is fair or not. Now I'll leave it off here. One problem with fair use is it's a defense against infringement. So if you're going to raise a fair use defense, you're already in court. And so it's an expensive shield, but that is sort of the nature of how fair use has been framed in the law. And so with that, I guess I will pass the baton to who's ever next.
Our next panelist is Abby North. She is a music rights administrator who regularly advises estates on catalog management and strategic growth concepts. She is the principal of North Music Group LLC and a founder of Unchained Melody Publishing LLC. Abby earned a BA in sociology from the University of California at Los Angeles and serves on the board of the Los Angeles chapter of the Association of Independent Music Publishers, the board of the International Association of Artists and Rights Holders US, and on the advisory board of Songwriters of North America.
I have to say, I love it. I love David's presentation. It made me think of so many things. And I think I want to start with my responses to what David said, actually. And the first one I want to say is every time I've ever sort of inquired about fair use with an attorney, the answer is almost always, we know it when we see it. So it's not a black and white, even though we have these four factors, it's certainly the evaluation, yes, it is or no, it isn't, is certainly not cut and dry. And as David said, it's a defense. You've already infringed, or there's an issue. So for me, I am a music rights manager, but I'm also a composer. And I'm also an advocate on behalf of songwriters and composers. So I tend to see things from multiple lenses. When for us as a rights manager, when we look at, there are platforms, user-generated platforms like YouTube, and YouTube allows creators to create video content, and a lot of those creators who create video content really aren't aware of copyright issues, and they'll use music, sometimes it's ours, in their content. Within YouTube, we have access to what's now sort of known as a standard technical measure, or in the YouTube world, as content management system. And that content management system lets me set my monetization status, meaning if a detection of my sound recording or my composition happens, I can say, I want to monetize it, which means, yes, I've licensed the user to use my IP. I can track it, which means I'm still allowing the user to do whatever they want in their video context, but I'm just going to keep track of the data related to it. And the third option is block. That means, no, you can't use it. So that YouTube CMS system gives me tools to, in some cases, prevent uses we don't want. Now at YouTube, what happens, one of the common, probably the most common attempt at using fair use as a defense is with the commenter videos, the reaction videos. So one of the biggest songs or most popular songs that we control is called Unchained Melody. And probably one of the most popular, if not the most popular recording of that song is by the artist, the band, the Righteous Brothers. And the reaction video will feature the Righteous Brothers, and Bobby Hatfield is the member who sings this particular song. And then somebody will sit there with the camera on their face and react. But it's not really commentary. It's really taking our composition and trying to monetize, like take away the monetization from us and move it to themselves. And they almost always, when Content ID with fingerprinting will identify the sound recording, and then we have made a claim on our composition within that sound recording that's been identified. And so a claim is made, right? It's automatically made by CMS on our behalf. And then the user comes back and says, oh, no, this is fair use. and it's not fair use. It's not fair use to take more, the entire song and react facially, and then expect that you should be able to take the money that we're supposed to be getting. Like, that's not fair use. Okay, so that is one, that's it for us today. That's the most challenging scenario, is monitoring what's happening at YouTube. Because here's the thing, we do want to allow uses that are educational. I mean, we're very focused on education. And certainly if something is like truly transformative, that's exciting. That is exciting. And we're open to that. but we don't see that very often. The other area in which fair use, I think, is prominent in music is in sampling. And there are cases like Pretty Woman, where Two Live Crew took a sample of Roy Orbison's Pretty Woman and commercially released it. And was it transformative? Well, it was commercial. So the judges ruled that I think the David Herlihy, you can confirm this one. I think the first pass was fair use, and then I think the second pass said no, it's, or the other way around. Not
No, yeah. So the lower court found it was fair use, and then Acuff Rose appealed, and the appeals court overturned the lower court's verdict, and then Two Live Crew appealed to the Supreme Court, and that really is the landmark case on fair use, especially with regard to music. And the Supreme Court felt that it was transformative, and they went through the 4 fair use factors, and basically because they argue we're making fun of the banality of Pretty Woman, especially as it was in the movie with Julia Roberts and Richard Gere. It's like, oh, look at the idyllic prostitute and her John. Isn't that wonderful, right? And so Two Live Crew is like, not so much, and they made their version of that work. And so a lot of my colleagues don't like that decision. A lot of my colleagues at Northeastern don't like that decision.
and at the end of the day, almost all of these cases, like Ice Ice Baby, they end up being settled, right? They rather than just saying it's fair use, we're using it, they do end up being settled, and all of the parties end up negotiating compensation for everyone. And that's, to me, that's really what it is. It's a sample. It's our, whatever it is, sound recording or composition. And if you're using it, the right thing is to compensate. And I will say that it's difficult for a documentarian to make money. That's not like, you don't enter the documentary business because you want to get rich in general. And in music, it's really hard now to make a living because of the proliferation of streaming and the fact, particularly on the composition side, there's so many compulsory licenses, and we don't get to set our rates in most cases on a fair market basis. So we're already at a disadvantage on the composition side. So it's hard for us when money that should be going to us and our writers gets diverted. I think there were a couple. Oh, I wanted to say the sharing the flame does not diminish mine that David brought up. I love that allusion because we do want to foster creativity. And if you're not, in some cases, and here's another YouTube scenario, wedding videos. Unchained Melody is a very popular wedding song. And there are many wedding videos that get posted, and they include Unchained Melody. And I'm completely supportive of that. And the reason is that these weddings are across culture, they're across generation, and they introduce our song to new audiences. And so I look at that as an example of sharing the flame. Go for it, use it in your wedding video, because it's going to help me too. We can share our flames. So that, and I do want to say there's one other thing and also in the YouTube context for us, and it's not solely YouTube, it's universal, but when we see objectionable uses, there is no question that we're taking that down. In my opinion, one of the main problems with the Digital Millennium Copyright Act, the DMCA, is that if I take it down once, it doesn't stay down elsewhere. And so I'm constantly having to monitor the detections and take it down at multiple channels. And I think that's wrong. That's one of the applications that I would like to see advanced. And that's my take.
Our next panelist is Annie Berman, a media artist living and working in New York City whose most recent film is The Faithful, The King, the Pope, and the Princess. Her work has shown internationally in cinemas, festivals, galleries, and universities, including MoMA, the Spring Break Art Show, and the Rome Independent Film Festival, where she was awarded the Best Experimental Film Prize. Annie holds an MFA in Integrated Media at Hunter College and currently teaches film at City College.
Since I'm not on my normal system, so I'm traveling. But it's so good to be here. Thank you, David, for bringing us together. These are very healthy conversations to be having. I came to this by means of starting out making a documentary. Being right out of college, my influences were experimental artists, who use collage and comment upon culture. Larry Lessig was a huge influence for me later on, because I started making this film just believing that I had the right to film the world around me, comment upon it. And then I was met with all of this fear and resistance from distributors and or funders even. And so a lot of the process of making the film was to begin to understand what my rights were. And this was a long time ago. This was early 2000s. So Free Culture hadn't yet, the book by Larry Lessig hadn't yet been published. The Statement of Best Practices in Fair Use had not yet been published. And with both of those, I became stronger in my beliefs that I did actually have the right to do what I was doing. I actually met with Larry Lessig during the process of making the film, sat down with him and interviewed him, and he told me, yes, I did have the right to do what I was doing, and if I were to continue to do it, it wouldn't be easy, but I would be doing a service to other artists, which did inspire me to keep going. But I had very little funds, couldn't afford a lawyer. I was appointed a volunteer lawyer for the arts very early on, again, before Creative Commons and before the best practices. I also had a co-producer who worked in television, and both the volunteer lawyer for the arts and my co-producer were telling me what the law was based on their own assessments of risk and not actually the law. And so I think this is a really important thing to think about, is that I could ask different attorneys, I could ask different judges, and I could get a different answer. And this is very challenging when you're making work, right? And what I ultimately learned, because I had this feeling of shame, really, like I'm doing something illegal. I don't have the right to do this, and fear because of that. But to find out that it really is a risk assessment, like the more people I talk to, the more I realize, it's what you're comfortable with, what your risk is. I talk to people and attorneys in different countries. I also started to realize this is an American phenomenon, the fact that we sue each other as much as we do. I had to get permission for my fair. So I went through all of the steps to get an opinion letter. So we went through every frame of film, every bar of music, and had it all cleared in either we licensed it because it wasn't fair use, or it was, and we have this letter, opinion letter. And I will say that even with it, it's still not that easy to get the insurance you need. I did get it, but it's still in a risk assessment. So even if you come on the side of fair use, you have the attorney letter. Insurance agent can just say, well, we know this party is very litigious, so we don't really want to deal with it, so you really can be on your own after all of that. So I came out on the other side. I was deeply fascinated by this subject. I wasn't doing it just to protect my rights. I started to realize this was part of the story of visual culture, and so I started reading all of the case law to understand what my rights were. And as we discussed with some of those previous examples, one court, believes it's fair use, the other one doesn't, and then you appeal, and who has more money, and all of this. So it's it's a very difficult situation I think creators find themselves in America. And it didn't help that the robots now can determine things for us, and that we have to submit a claim and deal with non-people either. So so that's a brief intro into my thoughts.
Could you clear up one thing? Could you explain briefly for the students who don't know exactly what it is? What is the errors and omissions insurance that you referred to in your presentation?
Right. So errors and omissions insurance is something that a lot of distributors require that you have, so that it covers litigation if you were to go to court. So there is a deductible and a per claim deductible and all of that. So it's more it's insuring against any omissions that you might have made.
And by the way, just to chime in, as an attorney, I'm called upon to do these assessments of documentary films, and I'm doing one right now that's very, very music intensive, over 56 different compositions in this one documentary film. And the client hired a music supervisor to take care of the big ones, but I thought largely it is fair use. So they're going to ask me to opine about whether this is fair or not. And then I have a piece of paper with my opinion on it, and I give it to them. And then they can maybe go to a insurance company and they'll decide if that piece of paper is worth anything, and whether they're going to then take the opinion of this lawyer guy and provide an insurance policy. So it basically is an assessment. This is likely fair, and really to the issue really is lawyers are risk averse, right? And artists are risk takers. And so you're out on the high wire as an artist doing your thing, and the lawyer's like, hey, you should have a safety net, Maybe you shouldn't be up on that wire. Maybe you shouldn't be doing that stuff. And so lawyers by trade are risk avoiders and risk averse. And so it's rare to, not rare, but even lawyers will have different opinions about whether something is fair or not. And so it's an opinion, right? There are factors, but I think it's fair. Abby doesn't think it's fair. David thinks it's fair. Someone doesn't think it's fair. So it's very
It's ambiguous.
It's subjective. There are standards, there are factors, but it's subjective.
Abby, from a music standpoint, would you like to chime in on the errors and omissions conversation?
I'd like to chime in actually on two
Okay.
parts of this. David says, okay, attorneys are risk averse. So here's the letter that's, I'm going to give you this letter just to facilitate you getting errors and omissions insurance. And that's valid. But there's another side. And clearly in David's documentary example, they're licensing the big ones because the license is the insurance policy that you're not going to have to deal with problems down the road. And so this is a risk assessment. So the big licensors, we better just license them so we don't have to deal with them. Smaller ones, they're probably not going to give us a problem. So we're just going to take the risk. We accept that risk, right? So part of me is like, look, I totally get it. But at the same time, is that really right? I mean, is that really the right way to, from, good and evil? Is that right?
Right.
My second, and I'm not, I actually don't.
No, it's great. This is great.
Yeah. The other, and by the way, I also music supervise. And I will say that, it's hard. It's hard to clear things on budget. And it doesn't matter if you're making a documentary or you're making the movie about Elvis, right? It's really complicated because of things like Most Favored Nations, where, when we license something, it's with the caveat that it doesn't really matter what I quote, because if somebody else quotes more, you're going to pay me what you pay them. Now, so it's really, all of this is hard. And that's, I see all the sides. It's just sometimes we're like, oh, wait a minute, this doesn't feel right. That's generally how I kind of operate. Now, in terms of the errors and omissions insurance, music supervisors have errors and omissions insurance, composers or rights holders generally are now, we have to have errors and omissions insurance. And one of the things we face, so I put a note in the chat that so production music libraries, we have to have errors and omissions insurance now because many of our licensees require it. They won't license our music unless we have the E&O insurance. And it's one of those things that I'm really happy to have, because that reduces my risk. And that's really important to me, because the risk can be, if it goes the wrong way, it can be very expensive.
And just one thing I want to say, Abby, we looked in that documentary film, I looked at the film and looked at the uses. And even some of the small publishers with the uses were long, I recommended that my clients reach out and get a license. And actually, because it was a documentary film, many of them gave gratis licenses because they understood the nature of it. And so we actually, for things under 10 seconds or real background stuff, I was like, all told, and there's no bright line, there's no like 10-second rule, right? But I said, I think this is fair. I do. I'm not saying I think you're going to get away with it. I said, I think this is fair.
Yeah.
And then for the ones that are on the edge, I'm like, you know what? You should ask, but I think ask with your hat in your hand and say, I'm just a documentary filmmaker trying to tell a wonderful story, and I think this is an important thing to do. I haven't got a lot of money. It's a labor of love. I'm not trying to be a bad actor. And then even if they say, you got to pay me $10,000, it doesn't mean you forfeited your fair use defense.
Right. It's
so
your
you actually asked. So it is. But I encourage my clients to ask, unless they're really de minimis uses, 2 seconds, 4 seconds. But if you can recognize the work, unless it's short, I recommend they ask, and they have been asking. But the big ones, no matter Warner Chappell, Universal, no matter how short it is, you better ask.
And I got to say, I really do love it when attorneys have a creative background, because it makes it, this is not cut and dry. This is not, and you do have to evaluate it. And it is subjective. And so it helps if your subjective analysis includes, the perspective of a creative person.
Annie, so working with video and images is a little bit different than music in some respects. Would you like to offer us your perspective on the issue of reusing images versus music?
Yeah, well, I think, the images don't yet come up in that automated YouTube kind of way. I was warned most against anything that was taken by someone who might consider themselves more in the paparazzi camp. People who are really exploiting a photograph to its fullest commercial value are the ones who are most going to litigate or come after you in that kind of sense. I also did, though, find it easier Abby was speaking about how complex it is to license music when you want to, because I had a music supervisor and you need help because it's like beyond accessible to just an artist or a person doing it for the first time. With images, you can't always track down who the source is. That sometimes happens with music too, obscure music, and then so you do your best efforts to. I was also, I think a lot of this too. It comes down to. Larry Lessig gets into this about the middleman. It's like it used to be you could find a person who took a photograph, ask them for permission, have a person-to-person conversation. They would understand what you're doing. They'd actually be, touched that you asked them and want to be included in it. Now we have places like Getty that have bought up the collections of average people, and they put their stamp on everything, and they don't even. It's just a conglomerate that we're dealing with, and this has taken away the human aspect, honestly, and this idea that everything has this value, which we're not really sure what it is. It goes back to what I was talking about our country we've moved into intellectual property when we stop producing goods. And this, we have an overinflated idea of, I think, what a lot of intellectual property is worth. Out of necessity. I mean, you see it with the way we're commercializing our own images on being influencers. I mean, we're asked to do that because we have no industry in which to enter into when we graduate. So we are like hanging on, in my opinion, into intellectual property for our dear lives, you know. And so to me, it's gotten kind of perverted in the sense that it's just not the value that it could be. If you look at other countries, the value of images, the value of prescription drugs are reasonable. There's, you know, and so yes, I was at my most content when I could, this beautiful site Flickr that you can search by Creative Commons, and you can meet the person who took this photograph of, you know, their friend putting a Diana mask on their face, and they say, yes, I would love for you to use this image. I say, thank you, I'll put you in the credits. And it can work that way. It can work that way. If you are a person who's been chasing Princess Diana, hoping you're going to make your entire career and buy your house and retire off of this one photograph of her being chased to death, you know, you might, you know, not be so willing to share that photograph. And so again, it's back into integrity, intention, and all of these kinds of things. And what kind of world do we want to live in? So, I mean, I know this is not the practical panel ideas, but this is what I found in Larry Lessig and Creative Commons, and this is where I still would like to remind myself of the bigger picture and the idea we are just like ants on one planet in our solar system, and why waste all of our time with this, really. So I respect, I'm also in the middle, believe it or not, because I am an artist and people could reuse my work. So I do understand striking a balance, absolutely. I just wish it didn't involve so much money and lawyers and time. And I wish people could be reasonable and without threatening to sue each other all the time.
Yeah, I want to go back to something that was discussed earlier. Aiden had a really good question. Abby, you're okay with wedding videos using music that you manage the rights to. And how is that different than, isn't a reaction video also introducing an audience to that music for the first time? And if introducing a new audience to the music is like a good, okay thing, then why is it okay for a wedding video, but not okay for a reaction video?
That's a great question. So generally, when we get married and have weddings and we upload our videos, we're not really trying to monetize. We're generally trying to, like, it's a really amazing experience and it's emotional and we want to share that. And I'm all for that. When it's a reaction video, there are times where it's genuine, right? Like, meaning it's somebody who genuinely has just heard Bobby Hatfield for the first time, and that soaring high note is like so magical and inspirational. And I am behind that. And that does share in the magic of this song and the performance of the song. And I'm all about that. When we just have people taking advantage of something that they heard, that, oh yeah, if you go to YouTube and you just say, you just do these reaction videos, you can grow your channel and you can start to make money. That's not fair to us. It's not fair to take the money from us, right? So while it may introduce the song to new audiences, which we need and want, it's always like, we have to personally, subjectively evaluate the scenario and decide.
Got it.
Yep. And I think also, Abby, just to say, it's also, I mean, not to interrupt, it's transformative. Like when you see the couple dancing, or the father dancing with the new bride, or whatever that is, that's transformative. It's really you're contextualizing it yet again,
yes,
in the context of this loving moment, and that is tremendous.
It's actually so interesting that you're putting it that way, because I have this belief that, so it's really hard for songs to become what we call evergreens now because of the way music exploitation consumption has changed. And to me, the only way to make a song and a recording of a song be everlasting is by marrying them to visual images. So like an audiovisual context. And the examples would be like Pretty Woman in that movie, Pretty Woman, and, you know, Unchained Melody in Ghost, and You've Lost That Love and Feeling in Top Gun. And those marriages of song and recording to audiovisual, I think David's right. I think they do transform. They create something that's brand new and that makes all of the pieces become everlasting.
That's really, I really like hearing those perspectives. Thomas has a question for Annie. Can you talk a little bit about the issues with photography and public art or landmarks with, say, ad films doing photo shoots to sell cars or clothes in front of public artwork? What are your thoughts on that?
That might be more of a legal question than, I mean, I can do that. I mean, I do. For me, our visual culture is unfortunately a commercial culture. I cannot shoot a photograph of a person without like getting something in the background. So for me, that's incidental. I mean, of course, I guess you're talking about using it intentionally. I don't know, but David, maybe you could speak to the
Yeah,
legality.
actually, yeah, I think it is. There's actually black letter law in the Copyright Act that says you can take photographs of buildings and statues. So the exclusive rights of adaptation for, say, photographs don't apply to architectural works, sculptural works. To now, if you were to reproduce them, that would be, I think, then you can take the picture, but then what do you do with the picture? Like if I take a picture of a statue that's protected by copyright, and then I make posters and sell them, that would not be covered by that. But incidental photographs, or like even just commercials in New York City, or you see like a CSI, and they're going down the street, recognizable buildings, that's protectable. That's an expressive work. And so, but if you're taking that picture, and then like I say, then taking and then reproducing it as art itself, that would be an unauthorized derivative work. So you have to sort of look at these. It's the picture itself, and then the use of the picture. And so if it's strictly like copy shop copying of something to make posters, that would not be permissible. But incidental capturing of architecture and statues as part of commercials, that's and even movies, that's permissible.
Another question that Thomas had, and I'd really like for everyone on the panel to weigh in on this from their perspective, is what's going on with this perpetual renewal of copyright for the entertainment industry? Because the way I read the law is copyright is about a limited monopoly, and something that goes way beyond my lifetime doesn't sound to me like limited. What's going on there?
Well, I can tell. I don't want to monopolize, but I can. You're right. And actually, there was a case brought to challenge the legality of the Extension Act, the Sonny Bono Extension Act. They tacked 20 more years on to every existing term, plus 20 years on to any future term of copyright, really under the impetus of Disney lobbying Congress because they didn't want the earliest Mickey Mouse renderings to come into the public domain, which is kind of ironic considering Disney creativity and what Walt Disney was doing back in the day when he rendered Mickey Mouse. But the term gets longer and longer and longer, and actually Lawrence Lessig was the attorney for Eldred v. Ashcroft. They sued the United States, saying that this extension of the term of protection was an unconstitutional taking. It violated free speech, and it exceeded Congress's mandate, as David put it, for limited times. And the court looked at it and said, well, this is Congress's purview, and we're not going to challenge if it's good policy. They have the right to make the policy. and it's limited in the sense that it's somewhat short of eternity, I guess. But I agree that it's, the idea of being able to borrow from something, say 30 years ago, may bum Abby out, because if Unchained Melody is freely borrowable, then that's, but the public domain has really been impoverished by this extension of the term of protection, and it's not getting any shorter. I think there may be kind of ways that we can legislate around the kinds of uses that may be permissible, like maybe user-generated content, maybe put some, codification into the law. But it's, yeah, I mean, I think it's out of whack, personally. I think the limited time is 70 years after the death of the last surviving author. That's a long
That's here.
time. Right, I know.
And then Mexico is 100 years.
Right.
So
Right.
Annie, from a filmmaker's perspective, I'd love to hear your perspectives on this perpetual renewal that the entertainment industry has on copyright law, because you just know they're going to pass another law and do another Sonny Bono Extension Act.
Yeah. I mean, it's back to what I was saying. It just all comes down to who has more money and power. And so, yes, the public domain is suffering. Art in this country we see has suffered. We don't have support for the arts here. The libraries, which are the repository of the public domain, we don't fund. So it's across the board. It really. But there is there's Public Domain Day. There are people who release their work into the public domain. It's not to say that there isn't a movement and this kind of other culture, open source software, all of this kind of plays into let's create the world we want to live in. I think also of video artist Namjoon Paik, who had reconfigured the television, back in the day, so that people could remake new art out of the streams of the television. And if you think about the reality we live in today, the fact that the tools are in the hands of so many of us, and we can afford to make work, that's a tremendous thing. And so I think even I can see the tension and the questions involved in like a reaction video and things like that. But at the same time, that is the dream. That is the dream that we can. The boob tube, like the idea that we're this passive receptacle of culture and we're just being fed things to buy, and the idea that we can add to, and to me, adding to is transformative. I don't know, and I don't watch reaction videos, so I can't really comment on the transformative nature, but just in theory, the idea that we have internalized this music, we've internalized these images of Elvis, they are part of our vocabulary, part of our memory, part of our story, part of our history. And so there is this degree of censorship that the fear creates. When do I decide I'm not going to share this idea? Because the idea, it used to be, ideas were written, and even that was an act of people were fearful who had typewriters, because that was an act of power. Anytime you're creating, it could be resistance, and you can subvert the power structures that be. So there will always be a fight against people being able to express themselves. And we see all of these sides. We see fake news, we see, so you can see how complicated it is, and how there could be many of these conversations. We could do this every day. But yeah, that is the it's like the dream that we can all create, and what is standing in our way of doing that. And even this idea that we built the internet. Why did we make YouTube monetized in the first place? Why is it that we expect money from our videos? So these are all questions we can ask ourselves. And who's getting that money? Like, I might make 1 penny, and where is the money really going? I think if you follow the money and everyone could have a transparent conversation, we could see that the system is working for very, very few people. Which I heard in the beginning, right? I heard in the beginning about who's making the money. The composers aren't making the money, the musicians aren't making the money. And the more we figure that out, I think the more we can solve the problems ourselves. And I am, I don't want to sound like a complete pessimist, because there are things that I see hope in. And one of that is Grant for the Web is a new initiative that a Creative Commons Mozilla Foundation and COIL have come up with, that's trying to find new ways to monetize the web, that can support more of the grassroots individual artists, creators. And I released my film that way back in last March, just to show my support for that. This idea that you can subscribe to I think of like the dark side of the internet and the bright side of the internet. And it's like for $5 a month, your money could be divvied up to the sites that you're viewing and the content that you're consuming. And so that's just one method for and that's what I also appreciate about Lawrence Lessig, is that instead of lamenting the ways that history has come to be, he's always creating new structures and coming up with solutions. And so I don't think we have to give in to the way it is, because we wrote the internet and we can continue to rethink it.
I love what you just said, in a lot of ways. And the first thing for me is, so I mentioned that on the song side that licenses are compulsories, and so we can't set the rates and blah, 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 blah. But this Web3 metaverse provides an opportunity for all of us to get on top of this, the monetization structure, before it's too late. My personal vision is that everybody who is involved in, let's say, a metaverse experience or whatever we want to call it, should be participating in the 100% pool of money. And they should be able to identify themselves. They should be able to include their data on a chain, a blockchain, and there should be contracts that allow everyone to participate in the monetization. So should we have monetization? I think yes, but that's because I want to live and I want my kids to go to school and I want to pay them, buy the cars and all that kind of stuff. I don't think that only the musicians or only the composers should be paid. I think everyone should be paid. That's my personal perspective. In terms of the duration of copyright, one of the things we've seen happen in the music business is what we call checkbook publishers, or big investment funds acquiring like very important legacy catalog, the copyrights that earn a lot of money. And when we see these funds investing billions, and I think it was 5.5 billion in the last year or two that was invested in copyrights, those parties have a real incentive to see the term of copyright be extended. And I expect them to make that effort. For us, so we have, for example, Unchained Melody, it's not Life Plus 70 because of the year it was created. So it's 95 years from the date. So we do have like a sort of imminent expiration, and we, that's how we, like I said, pay the mortgage. So I always have to look at, well, what can we do if copyright term, if there's no extension, what can I do? Well, one of the things we do is we create sound recordings, because we want to be able to keep earning money after the song copyright has gone into the public domain. So we might do that. Another is when it goes to the public domain, we'll start creating new arrangements of that work, of that composition. So we can have new copyrights starting. So something going into the copyright, into public domain, I honestly, I don't love it, but I have ways to work within that structure.
So Amani had a question. If something blows up as a viral reaction video, but in a negative context, does the argument for or against fair use change based on the reactor's opinion? Right? There seems to be this gray area in terms of, from a rights holder deciding whether something is offensive or not offensive, or appropriate use or inappropriate use.
If it's from the rights holder's perspective, I think that's one thing, but I was interpreting the questions from the legal perspective.
Yeah, or maybe
Well,
from
the
the
thing,
legal
yeah,
perspective or the
well,
intention of the law? Sorry, David, go
well,
ahead.
no, no, I'm sorry. So criticism is an important part of fair use and parody, right? When you're making fun of something like the way Two Live Crew made criticized what they thought was the banality, right, of Pretty Woman, especially as it applied to the movie. And so they're criticizing that, and Acuff Rose is not likely to give permission for that, right? Oh, go ahead, criticize my work, have at it. You know, that's not people, rights holders don't do that. And similarly, if you had Unchained Melody synchronized into some truly racist, horrible, misogynistic video, that would be a synchronization that Abby would never allow. But nonetheless, I could say it's fair because of how I'm doing it, and I may be shielded for if it is fair. But it so the reaction of the audience isn't necessarily the kind of harm that fair use is meant to protect against. It's really, does this use supplant Abby's market now? Not does it make people feel differently about her catalog, but are people no longer going to listen to the Righteous Brothers, but instead watch this misogynistic, racist video? Probably not. I don't think it would supplant the value, but this is actually more akin to moral rights, a European notion of not having your work distorted or mutilated. If somebody does something that impugns the reputation of the author, that's much more of a European idea than it is an American idea. And Europe sort of allows more explicitly this idea of moral rights, where the author gets to um, uh, stop really offensive mutilations of their work. That's not so prevalent in the U.S., but it's somewhat more prevalent in Europe.
Thanks for that, David. Annie, I have a question for you. Going back to the origin of your documentary, because I'm sure you didn't set out to say, oh, I'm going to make a remix found footage film and challenge fair use, right? That only came out at the end. So tell us a little bit about how this project originated and how did it become a film?
Yeah, so I was still in college, and I was really interested in this idea of the image as reproduced, and the value of images and copies and replicas. Reading Walter Benjamin, Susan Sontag, those kinds of things. I went to Rome. I saw this lollipop with the Pope John Paul II's face on it for sale at a hot dog stand at the Vatican, and I loved that image for whatever reason. And I was shooting slide film, and I took a picture of it, but it jammed my camera. But I was still shooting slides because I thought, oh, I'm going to reproduce this image even further. I'm going to use Polaroid transfer and transfer this picture of the Pope on a lollipop onto different surfaces. And that was going to be my project, not a film. And so sometimes I think if, the camera hadn't jammed, I wouldn't have made the film because I would have done that. But so yeah, so I was thinking about, it's not that weird that we commercialize this Holy Father, maybe because in my country, in America, we do this with Mickey Mouse. I was thinking of Mickey Mouse and Elvis, and I didn't know much about Elvis. I'd never been to Graceland, but I just was drawn to this idea. And so got in the car. I just graduated college, was temping and looking for real work. I tried to get a job on a filmmaker I liked film, and she said, "You've gotten grants before, you should make your own film." And I had this idea in mind. So friends said, "Oh yeah, we'll go." And so we went to Graceland and started shooting. Realized that we weren't going to get any permission to shoot there early on. They were very strict about which press would even get access to the property. But it seemed okay because we knew that we could shoot on the street and in public property. So all of that just seemed fine. We were talking to people. It wasn't about his music. It was just about his face. I didn't yet know there was this thing, right, of publicity, which is the ability for a person to commercialize on their name, image, and likeness, and that this could be an issue at all. And I was just filming, and so then I just kept doing it. But at some point, it was when I was trying to submit it for funding, where I met with a fiscal agent, and I sat around a table with like 12 of their members, and every question they had for me were rights based, and and they couldn't even listen to my answers. They were like just like riffing and rolling and just like thinking, how can you possibly make this movie? And I should say my mom, who actually I think is here listening, she's a painter. I grew up, being exposed to art and thinking that I wasn't doing anything illegal, and I always kind of lived on the safe side of the law. And so yeah, I just started to try to understand both my rights, but also it really felt inherent to the story itself, because when I was thinking, well, why is Elvis so big 45 years now after his death? And one possible theory, some people could say, is because his estate did such a good job cracking down on, anything and really promoting his image. And the history of the Elvis estate is actually quite fascinating. And it could be a whole film, and it kind of was at one point for me. And there's a book called Elvis Inc. And there's also a wonderful essay online called Policing Elvis, which traces the history of their ownership and control. They sought advice from Disney when they started. It's a fascinating story. When Elvis died, his estate had very little money. His manager had totally mismanaged Elvis and had sold all his best hits, most of the music, to RCA. So the estate was left with the house and a lot of bills, and I think, his former wife, who was the executor because his daughter was underage, I think she was a very savvy business person, and she figured out what Disney was doing right. She helped lobby the courts to pass some of these rules. They extending right of publicity past death and all of this, which didn't exist for always. It used to be when you died, your right of publicity died with you. And so, yeah, they continue to be on this side and lobbying the courts. And Tennessee, where the state that Graceland is in and Elvis's house is an entertainment capital also, because you have Nashville. And so the courts were understood that. And so just like you have California and New York, you have these entertainment capitals. And they went on to give advice to Martin Luther King Jr.'s family. And we could look at that too, about how that speech that should be, I understand a family's desire and need to also make money, but that speech is our history, and it's such a needed part of our history. So it's like there's a tension with all of it about what is our history and who gets to use it and control it. And so yes, and then one year that I was still filming, the whole enterprise was sold to this billionaire media mogul, Robert Sillerman, who CKX was his company. They owned Muhammad Ali, who the name, image, and likeness, David Beckham, who was still and is still alive, which is like, how do you own someone's image who's alive, and what does that mean? And you're just buying and trading people's intellectual persona. It's so so she sold, Lisa Marie sold the whole thing for $100 million and some shares. That company then went bankrupt. It's been sold several times since. They're trying to pick up the pieces. Again, they're left with very little. I think they're behind this new Baz Luhrmann Elvis movie coming out with Tom Hanks in June. And so that should, again, raise Elvis's profile once again. But it is that tension about wanting somebody, and I sat down with the owner of the billionaire Robert Sillerman when he was still alive, and it didn't make it into the film, but I interviewed him about this idea about this desire to who is a person he would buy, right? And so Elvis, Muhammad Ali, what do they have? It's like that they become at some point not a person but an idea, right? And so it's that's what I'm focused on in The Faithful, is how does a person become an idea? What does that mean? But then it's an interesting thing, because how do you own an idea, right? And that's the tension. So he, on the one hand, and he was saying it, not thinking that there is a conflict, that he wants Elvis to be in everybody's memory bank, internalized, live inside their hearts, but at the same time, he wants control of that. And so Erica Doss wrote this book, Elvis Culture, Fans, Faith, and Image, and she also tracks some of this, and she ends with this idea about if you limit something, if you limit the degrees of interpretation, you're also limiting the phenomenon. So when you think of phenomenon, it's because there are infinite interpretations. I can have my vision of Elvis, you can have yours, and that's because he has achieved that iconic status that is the goal, really. But then it's like wanting to have it both ways. And that's what we see as the tension play out.
David and Abby, would you like to weigh in on this tension? Because that's really at the core of what this discussion is about. That tension between our First Amendment rights to express ourselves, also the purpose of the law to fuel innovation and creativity, and at the same time, the rights holders limited monopoly on these materials,
Yeah.
and the added twist that if something becomes an idea, can you still consider that copyrighted?
Well, so there's a bunch of different buckets that these things fall into. One is copyright, which is creative works. So musical works, including lyrics, sound recordings, graphic, pictorial, and sculptural works, architectural works, pictorial, graphic works, and so forth. These creative works, and what's protected is the original expression of the person who fixed that. So the choices that they make. So, and that lasts life plus 70, or for a work of corporate authorship, 95 years from publication, or 120 from creation. Long time. Another bucket is trademarks. Trademarks are anything that identifies the origin of a good or a service. So Elvis, in addition to being photographed, so the photographer owns the copyright in the photograph of Elvis's face, Elvis is actually a trademark of the Elvis enterprises. So, and trademarks, unlike copyrights, actually live forever. So as long as you're using a trademark in commerce, it's not limited in the same way that a copyright is or a patent is. So branding, and a brand can also be part image. So like Mickey Mouse's shape of his head, on the one point, that can be a copyrightable rendering, but can also be used as a trademark. And so the function of a trademark will never end as long as that's still being used. So then you also have publicity rights. So the picture that I took of Elvis, I could put that in a book, or maybe Annie could put it in her film, because that's a transformative, expressive work, and there's some latitude for uses of copyrightable works in other follow-on creative works. However, if I wanted to make Elvis cola, right, and use that Elvis picture on the label from my cola bottle, I would be misappropriating Elvis's right of publicity to sell products, and to advertise or promote products. Elvis Cola isn't a creative work, so I need the permission of the photographer who took the picture of Elvis. But then the way that I use that picture might be impinging on his publicity rights. And if I use Elvis as a word, it could be violating the trademark rights of Elvis Enterprises. So you have all of these intangible intellectual properties kind of merging together into this like nether zone. And you have someone like Annie who comes along who wants to talk about what Elvis means to us, which is an important thing to be able to do. But her recipe is going to be speckled with all of these ingredients that someone else can lay claim to. And so then she's got to be careful about how she integrates these speckles of ingredients, making sure that each one of them is fair and brief, and the overall purpose is the overall effect is transformative. It's like, it's a thicket. It's a thicket.
Abby? Something on the thicket?
No, Priscilla Presley was brilliant in the way she maneuvered. And Okay, so and from the estate perspective, and I mean like the recording artist or songwriter composer perspective, I would say that everybody looks at the Elvis example, at the Priscilla example as like, you know, the in the path to creating a legacy. I look at so by restricting the access, they were creating value. If you can, you know, if you can only access, if you, the only way to see Elvis is to come to Graceland, and we're going to charge you money to get into Graceland. And Elvis had that, you know, the thing that you can't force, that personality that everybody wanted to touch, but she grew it. Priscilla grew that, the image and the, I think, the attention. So I think limiting access does, in this case, where people want it, limiting the access does increase the monetary value. And it does allow her to protect it a little bit, because he wasn't necessarily like, you know, he wasn't a paragon. He wasn't a perfect guy, but he sure seems to be like, she did that. She made his image be like better than the real guy was.
Well, you know, Elvis is go ahead, Annie.
Oh, it's so interesting though, because the rebel part attracted a whole nother set of fandoms that then they don't cultivate, right? And then also it's like the capitalist dilemma, which Erica Doss talks about. It's like reap it now, but then what's going to happen? It's like that little core audience is dying, sadly, you know, and now they're at this turning point. So it's like, yeah, they maximized it for that moment. And so, yeah, so I don't know that it's a perfect solution as far as like even the monetizing part of it.
But she grew it she grew it so big and they made so much money that even if she never makes another penny,
it's actually not true, because they actually, I think she's technically bankrupt now, Lisa Marie, they're suing a lot of people. There were good business decisions and then there were poor ones when they sold for the $100 million and then that company went bankrupt somehow. So I think they're banking now on this Baz Luhrmann movie, but yeah, there was something else I was going to say, but now
I put in the chat that the last song that Elvis sang was Unchained Melody.
Oh, yeah.
This is all connected in so many ways.
Yeah, and so we licensed Unchained for the trailer. So you'll see if you watch the Baz Luhrmann trailers, it's you know,
yeah,
it's very meaningful. I mean, it's super meaningful to see that, like, what a great marketing job they're doing.
So we've got some more questions coming in on the chat here. So this is a question from Dallin. Annie, why do you think cameras were not allowed during the Elvis commemoration tours and other events, given you recognized we have an impulse to share with others, a mission to keep this going?
Right, it's entirely that. It's the limiting access and just being very tight about that. At the same time, you know, it's a tremendous, it's created as a press event. I mean, not exactly, because the very first Elvis Week was fan generated. It was not its idea. Fans just showed up with candles and then said, wouldn't it be nice if we could march to the gravesite every year? And then the CEO agreed and opened up the gates the following year. So it really started with the fans, but then it became co-opted by the estate. And over the years with the different owners too, they've done different things, like that part has always been free to take part in the candlelight vigil. It's always free to walk. You don't go inside the house. You could always go up to the gravesite early in the morning before it opens, at the end of the day. I mean, Elvis's father this used to be in the film, but he did this unthinkable thing. He knew how much Elvis's fans meant to him. And so he opened up the gates to the public for the final viewing, which, I mean, who would do that? Anyone could walk into the house, see his beloved son lying there in state, you know. So I guess that is also that sense that Elvis permitted the closeness. That if I answered the question, why is he so big today, I would say it's all because of Elvis and how open he was and how giving he was, how his autograph was less valuable than other performers because he gave so many of them. He gave the shirt off his back, he gave Cadillacs, he gave, his necklace, he gave everything away. And he got that, he got that the fans are what made him. The more he gives, the more they give back. And so I think that people who knew him, those fans, I think they do get put off by the estate and how they're treated because they feel that it becomes a Disney World, and that they're not going for that. They're not going for that works for a one-off thing. The people who are passing through in the country and want to go to Disney World, they'll go to Graceland, but they go one time. And so when you think about monetizing and is that the smartest business move, you also question, like maybe there was a woman who I became close with, who I interviewed, who wasn't in the film, Patsy Anderson, who was the fan relations manager for her a long lifetime. She started out as a fan, she was a volunteer tour guide, and then she rose in the ranks into fan relations manager. But when they let go of her, there was no one in the organization who represented the fans who was a fan. So it was very far removed from fandom because it was also focused on the business side of it. And I think, and that is the sense of, I think when we think of Mickey Mouse, we also think of a very sanitized figure. And I think that what some of the artists I follow were doing, were showing this complex, like Kata Phillips says, a lot of people collect her work because it's what they think of when they think of Elvis. They think of the Velvet Elvises, the selling them on the side of the road. They think of some of the, more of the underbelly of our culture, and that part got erased, and it's a little bit strange. But that unlocks Elvis for a whole other segment of the population, and maybe it doesn't sit comfortably with his family. I could understand that, but then I guess when they sell him, it can be whatever you want. But I guess your question was getting access. They would the press were all allowed access, which it is good, and who was on the news and all of that, but lay people not. And this is again before cell phones were also cameras. So now it's kind of it's funny to think about, no cameras are allowed. I mean, we're all a camera. We're like, our bodies are cameras now. And so clearly everyone's filming and it's disseminating everywhere. And there's only so much control in that sense you can have these days. But again, that same tension, it's like their marketing people are saying, okay, take these photos and hashtag them and like tell us these things because we need to spread it. And then the legal side is saying, absolutely not, you can't use your camera on property. So there's built in again the same inner dialogue. It's like the two shoulders of your consciousness arguing with itself.
Yeah, so we have some other questions coming in now. And if you could answer this briefly, Annie, but I think a lot of people are curious about this, did you consider on focusing on other individuals, or how is it that you ended up with Diana, the Pope, and Elvis?
Yeah, I really wasn't thinking at all. I really was like the receptacle. They chose me. And so the Pope just happened. He was on this lollipop. That made me think of Elvis, ended up at Elvis. Diana was a little bit different because it was just the two of them, and it had a different title. It was called Our Father the King. And when my co-producer, Sarah Terrio, came on, she was really pushing for Diana. And I eventually gave in, but I just wasn't sure she was really as big. She had been gone 5 years at the time. And it wasn't as at Graceland, he lived and died there. So that was the site, sacrosanct, that's where you go. Diana, that was her home. And when she divorced, she moved out. She died in Paris. So there wasn't this central place. But when I heard fans do gather at the gates, maybe, it could be a thing. And it was nice to have a woman, another country, a different realm. I was done shooting when Michael Jackson died. If I hadn't been, I would have really wanted to go there. So yeah, but that was how those three came to be.
And we have another question for Annie. You're getting a lot of questions today, Annie. And Abby and David, please chime in with legal and rights perspectives. Shreya asks, how did you personally navigate the usage of footage focused on Elvis or his music near the release or the promotion of the film? Especially, you mentioned his estate's infamous need to shut down artists or impersonators who use Elvis's images in any manner. So how did you pull this off? Because there's a lot of Elvis in your film.
Right. So that was all going through. At first, I was at this legal clinic, Cardoso School of Law, and they had student team overseen by faculty attorney, the director, going through all of it, making the case. So yes, it's a very arduous process of documenting everything, the source, where it's from, the duration of the original material, the duration of what you used, whether you're borrowing from one source. If everything I took was from one source, that would be lazy, but it would also be I'd be taking more from that and leaning on their work instead of my own. Um, but, for many years I didn't show anything, and actually that original lawyer, the volunteer lawyer for the arts, she told me to avoid using anything with Elvis. That was the first advice I got, so that's when I also just kind of stopped for a while, and I felt just very guilty and bad. I said, well, what about when I'm interviewing a fan at Graceland and they're wearing an Elvis shirt? She's like, yeah, it's better to avoid it, but right. So then I just had no idea. Then I'd like, well, I've been making this already for 5 years. I guess I don't have a film. And I had then talked to other people who had the same thing. There was a theater director in Connecticut who'd written an original musical, and it was in rehearsal and everything. And they had pre-sold tickets, and she got a letter. They didn't really even investigate if it was within their rights. Her board was terrified and angry. They thought she hadn't done her due diligence. They got her into this mess. They shut the whole thing down. The whole theater went bankrupt, I think. And she was so traumatized by it. She didn't even want to talk about it. And so she didn't do an interview or anything, but I mailed her this book, Elvis Inc., just to make her feel a little bit better about the situation, that it wasn't her fault. But this was I met this woman who, Andrea Berman, not related, but same last name. She was a graduate student in the late 90s, and the internet was new. And she was taking a computer science class, and they had to create a website. And so she's like, okay, what should I make a website about? She looked at her desk. She had just taken a trip to Graceland with her mom. And so she had photos that she scanned and and she called it a virtual tour of Graceland. Well, there were no sites on the internet. So when all the newspapers and magazines were covering what is the internet, they would point to, oh, and you can take a virtual tour of Graceland. So the estate, needless to say, heard about it and sent her a letter at grad school. She got this certified overnight letter signed by 20,000 lawyers. She panicked. She signed it. Yeah, she signed it, sent it back next day. And then she told people in her department, and they told people in the legal team, and they said, we have a whole law school who would love to have the first infringement case. We would have taken it on. We wish you hadn't signed it. And she said, this isn't my fight. I'm a graduate student. And so, but these are the kinds of things. And it is when we were talking back to the law, like this idea about risk, it's also a matter of weighing practice. It's just like, my feeling and is that I feel it's a right, and that, like a lot of rights, when we don't use them, we lose them, right? So my co-producer, who was working in television, she wasn't basing any of her opinion on the law, but just what she was told to do at her job, clearing things in TV. So she's like, no, you can't do that, you can't do that, you can't do that. I said, but on what basis? And so that becomes practice, and practice was very, very risk averse and very conservative. And it didn't have the tools, because we couldn't at the time get errors and omissions insurance. We didn't have the statement of best practices of fair use. And that enabled the practice to open up a little more the actual usage. And that's why I felt that ultimately, as grateful as I am for the legal clinics and the work that they did, ultimately, by going to somebody in private practice who sees a lot more of how these play out, like Abby was saying, how so many are settled and all of this, understanding that actual practice can help you make better decisions about your risk. And that's ultimately I mean, just hearing that very few, I knew very few went to court, and you can understand why, because say the rights holders lose, they lose everything really, because that's what they have. That is their business. So they have every incentive to settle outside of court and all of that. So, but because of that, when you settle, you sign something saying you're not going to tell anyone. Like so we don't have that information. So we really, we're all just floating around, blindly, and just having to trust what an attorney tells us, and pay an attorney a lot of money. And it's so that is I don't even remember the question. I'm sorry.
Well, that's okay. We need to start working towards wrapping this up because we're about to come up on the half-hour mark. So basically 2 minutes each at most, hopefully one. Just a little bit of wrap up on some food for thought that you would like to share with our audience today, starting with Abby.
I wanted to go last.
Sorry.
No, I don't know that. I mean, like, I really don't know what I want to say here, so I'm going to just wing it entirely. I will say that as somebody who makes a living from copyrights, all these tensions, I recognize them and I'm sensitive to them, but we still have to earn a living and we have to, support our families. And so we, as rights, on the rights management side, we have to work to protect the intellectual property. As the creator, like, I hear Annie, everything she's saying, and I don't disagree with any of it. Like, I just don't. I see it, I understand it, but it is some of it is in conflict with my ability to earn a living. And so that's where I think one thing is that we need to understand that there has to be compromise today, right? But I also think that we really need to be looking to these future technologies like the Web3, like metaverse, NFTs, and we need to very clearly identify what the rights are that are required. And we need to, in advance, figure out how we're going to monetize, how we're going to track, how we're going to license, and how we're going to facilitate every one of the participants being able to do so.
Excellent. Thank you for that.
Thanks.
Forward thinking, what we need to do next perspective. David.
Yeah, this has been great. I really enjoyed this. And so what comes to mind is the elephant in the room, which is capitalism, which is profit, which is, there's an economist, Joseph Schumpeter, who talks about creative destruction, and he likens capitalism to evolution and survival of the fittest, and seeking the profit motive, and human beings, as ingenious as they are, the profit motive is going to be a driving force. So can you somehow inject some guardrails, some barriers, some framework within which capitalism, which is not going away, and frankly, sometimes when you put in guardrails, you close the whole road down because the guardrails are so clumsy. So you can't just say capitalism bad and toll booths and everything. You have to. It's difficult, right? And so something that Annie said, which made me sad, is that a creator feels ashamed by the work that they're doing. Shame, like, that's just wrong, right? You're not doing something shameful. You're trying to actually contribute to knowledge. You're doing the very thing that copyright is intended to foster, to express and to tell a story, okay? And so, so you have, great thing about kindergartners is they ask the question, why? Why? So when a lawyer says you can't do that, why? And then get at the why, right? Yes or no is a position. Yes, no. Well, why do you want to do this, Annie? And why does Abby think that she would like this not to happen? And ask why? Because you take a position, but your position is based upon your interest, and you get at interests by asking why. And the law is complex, incredibly complex, But it's really trying to make sense in the end. It really is trying to make sense, but the application of it, which costs a lot of money, yields results that are torturous to even engage with the process, right? And so these things settle because it's just so freaking expensive, and no one likes to pay lawyers. I get that, and it's hard, and it's pressurized, and
Yep.
so anyway, it has to make sense, and so lawyers and risk-averse people and creators should always ask why, and then hopefully we can, create a framework that is that promotes progress.
Thank you for that, David. And Annie, what would you like your fellow media makers to take away from today's discussion?
Yeah, well, it's been such a fascinating discussion. Thank you all for, I really enjoyed this so much, and David for organizing.
Both Davids organized, by the way.
Oh yes, they both Davids. Thank you. So yeah, this was incredible. I was, there are a couple things. I mean, Lewis Hyde wrote this book about the gift and thinking about the artist over time, and that in it there was this idea that the difference between art and commodity is that it's received as a gift. Art is received as a gift, and so it's given as a gift, even if it needs to make money. Its intention is as a gift to our culture, right? So it's I mean, for students, I think you have to make the work that you have to make. I tell my students that too, work should be made from that place of passion, of integrity, and for me, it all comes down to intention, and I ask my students to articulate their intentions. And I think as media makers, artists, we're we're in a good position to make those right decisions because our work can also be used by other people. And so I think that you can ask yourself, you're a good moral compass, because you could say, if somebody did this with my work, how would I feel? Would I feel that they've gone too far or something like that? I was also, and when you think about art, and there's such a spectrum from the commercial to the purely artistic too, and thinking about where your art is going to live and who is it in conversation with. So recently I hosted a workshop, and one filmmaker whose film is on the Criterion Collection, these concerns don't ever cross her mind. She was trained at Cal Arts, it's like there's a whole history of collage, and so she doesn't ever consult a lawyer. She makes the work she's going to do, and it finds its way. And so again, I think that why question is a really great one, because there are all these sides. If you meet with any one person, you're quick to say, oh, they're this expert, they told me this, and therefore it's like this. But asking yourself also why you're creating the work. And I think that can also be helpful.
Thank you for that, Annie. We need to wrap things up. So thank you, everyone, for joining us today for this panel discussion. I think it's important that we understand that these tensions are about finding a compromise, as Abby shared with us. As Annie reminded us, that we really need to think about our intention and express ourselves. And as David recommended, we always have to keep asking why. So thank you very much for joining us today. And that concludes our panel of the First Amendment versus copyright.
Thank you so much.
Thank you so much. It was really fun.
All right, I'm going to stop the recording.